Look, my name is John Marshall, Chief Justice of the Supreme Court, and I've established some important legal precedents. In 34 years, I've done a lot. Like, in Marbury versus Madison, I established judicial review, but I think you know that. Or in Fletcher versus Peck, with repealing corrupt laws, and in McCullough versus Maryland, making federal power greater than the state. Let's get this thing started. I'm beginning to establish legal precedents. All my decisions serve as law in future cases. Now I know my laws last long enough to stay hot. They say to judge like a robot, so call me Judge Bot. I've been justice since 1801. I got a gavel in my back pocket. My pen I'll keep on signing documents. Got fat stacks from that judge profit. Made a living and a killing off it ever since John Adams was still in office with Thomas Jefferson right up behind him. I'm a justice, still as honest, but I turned down a position as Secretary of War. I'm not about that. I'm a justice. This flibbity-dibbity-hibbity hip-hop, I really want to do something other than law. I was an attorney in Richmond. I was elected to serve in the State Assembly, Executive Council, and at the same time, I helped to secure the ratification of the Constitution of Virginia, and I was still able to serve a diplomatic assignment in France by President Adams as part of the XYZ. Only realized it was ironic. I was signed to this mission after the fact. How could it not go? All I do is drop truth bombs. I returned to get elected into Congress in 1799, then became Secretary of State in 1801. You know my first official act? I administered my presidential oath to my rival, Thomas Jefferson. I'm beginning to establish legal precedents. All my decisions serve as law in future cases. Now I know my laws last long enough to stay hot. Let me show you Marbury versus Madison. Ain't that hard? William Marbury was appointed as Justice of the Peace in the District of Columbia. This was Adams as president, then Thomas Jefferson took over. Madison was Secretary of State. Madison refused to deliver Marbury's commission, just constantly refused him. Ooh. They both got taken to court from this issue because Marbury wanted a writ of mandamus. This would force delivery of his commission. Me, I denied the petition. Didn't have to give him commission. An act from a politician, Section 13, 1789. Not authorized to issue this writ despite the Judiciary Act. To issue this writ would be a violation of the Constitution. Even though this act says such writs may be issued, this section of the act is unconstitutional and is on the wall of shame. We decided this unanimously, to refuse to issue the writ. We sympathize with you, but can't force Jefferson to do anything. This created judicial review. In the short term, the effects denied power to the courts, but in the long term, this increased the power of the Supreme Court and the judiciary branch. It's the duty of the Judiciary Department to decide what the law is and interpret it. If the law and the Constitution apply to a particular case, the court must decide which rule governs this particular case. Judiciary review means that the Supreme Court can review legislative act like Judiciary Act of 1789 and declare its constitutional validity. Because I'm beginning to establish legal precedents. All my decisions serve as law in future cases. The way I interpret writing, call me Shakespeare. Another precedent in Fletcher versus Peck. Alright, let's go back to 1795. The state of Georgia sold 35 million acres of land in the Yazoo area. They sold this land to 4 different land companies. But the state legislature changed. New members were voted in, replacing those who sold the land. And they repealed the sale. All property gained from the Yazoo Land Act is invalidated. However, those who purchased the land continued selling it to third parties. John Peck sold 15,000 acres of Yazoo land to Robert Fletcher. This prompted a lawsuit from Fletcher for selling him land that Peck wasn't able to sell. After the contracts had been voided, the Supreme Court had to decide, could the state legislature cancel the private contracts? Is this a violation of the contract clause? The clause states the following. That states are prohibited from interfering with private contracts is said in the Constitution, but sometimes when you combine corruption and fraud and bribery, you get too big, and here they come trying to change the legislature like they did in 1796. So now here I come trying to say that a state government cannot make laws interfering with private contracts or land titles that break the contract clause and it's unconstitutional. See if you get away with it now that I established this new precedent. And now, the Supreme Court has the right to review and remove state laws as unconstitutional, and contracts and property rights are protected from states by the federal court system protecting individual rights. And now I hope you understand what happened with the original grants, because they're still valid due to the contract clause written in the Constitution. Man, oh man, that was the first state law the Supreme Court declared unconstitutional, even though the state legislature can repeal corrupt laws. Hey man, I established that. Lyrics coming at you with subsonic speed. Some of them I'm a human. What I gotta do to get it through to you, I'm superhuman, innovative, animated rubber, so that anything you say is ricocheting off of me, and I'm a write it down. I'm devastating, more than ever demonstrating how to give defense judiciary routes. I'm feeling like they're always staying, never fading into the Federalists are forever and further than they can say. I felt so celebrating because I knew how to keep them motivated. I make legal precedents using newfound evidence. Oh, I've got one more. Well, that's McCullough versus Maryland. In 1816, the Second National Bank was established by Marshall to combat debts from the War of 1812. Oh, my name is Thomas Jefferson. I'm gonna tax the bank in Maryland.
James McCullough was a banker in the National Bank in Maryland, and he refused to pay the tax, thinking the states didn't have the right to tax the National Bank. After a lawsuit, the Supreme Court had to prove the states didn't have the power to tax the government.
Necessary and proper clause is Congress's power to make all the laws regarding execution of their powers. This means that Congress has the right to create a national bank. In addition, the states don't have the right to tax the national bank. State actions cannot impede the federal government. Now, the legal system should broadly interpret the necessary and proper clause and let Congress decide how they wish to execute it.
Also establish the precedent of national supremacy, forbidding states from interfering with the constitutional operations of the government. Then you may be a little patient and more sympathetic to the situation and understand flexibility of new issues. The world's going to change, so we need to adapt to new problems. This case also strengthens the power of judicial review over state governments. It's a fatal mistake if you think I didn't change history and American federalism by establishing legal precedents. Be a king? Think not. Why be a king when you can be a god?